There is nothing that prevents a defendant at any time in life from declaring bankruptcy and seeking to have any judgment discharged. The question is, will that be successful? There are all kinds of grounds upon which you may bar a debtor in bankruptcy from discharging either a particular debt, namely the one he owes to you, or you can bar a debtor under certain circumstances from discharging any debt. The interplay of those two things is a matter of strategy and tactics, as well as an assessment of the facts and the law. In general, the type of RICO claims with which I am involved involve one form or another of fraud. And in general, fraudulent activity of specified types under certain circumstances can be barred from being discharged, or the judgments that have arisen from that activity can be barred from being discharged in bankruptcy. But you have to bring an adversary proceeding inside the bankruptcy as a separate lawsuit that you file within the bankruptcy court for that determination. My answer is not meant to say that any RICO or state court similar statute, that any violation there could so qualify for being barred from discharge in bankruptcy. I'm dealing here principally with the items I've spoken about elsewhere in these videos, principally arising from mail fraud, wire fraud, and securities fraud. But there are other activities. The statutes encompass illegal possession of firearms, explosive and incendiary devices, all kinds of things. Money laundering would probably qualify depending on the facts and circumstances, because there's probably going to be some fraud involved of the type that the bankruptcy code discusses. And that's where you have to look to see what types of fraud would be barred from discharge. But it isn't an automatic ticket just because he's or she or it has filed for bankruptcy protection. They don't automatically get that ticket punched and say, oh, you're out of here scot-free and don't have to pay this anymore. It can be prevented under a variety of circumstances.